I'm Ben Meiselas from the MeidasTouch Network. Things are heating up in the frivolous $500 million lawsuit that Donald Trump brought against Michael Cohen, my co-host on Political Beatdown here on the MeidasTouch Network. And we checked in with Michael Cohen on Political Beatdown to see what's going on with that case. And Michael Cohen read for us exclusively here on the MeidasTouch Network on Political Beatdown the reply brief that he and his lawyers were filing in the Southern District of Florida federal court, where Donald Trump brought this ridiculous claim. And Michael Cohen also mentioned that he has set the deposition for Donald Trump last week, and Donald Trump has tried to avoid this deposition. Donald Trump brought the case and is trying to avoid having his deposition taken in a case where Donald Trump is the plaintiff, just the coward that Donald Trump is. But let's hear it in Michael Cohen's own words, what's going on in his case, where he has filed a motion to dismiss Donald Trump's $500 million BS lawsuit. Play the clip.
You'll understand just how good the lawyers are that I have on this specific case in order to hold Trump accountable. We received, as you may recall, we received the $500 million lawsuit. We put in our motion to dismiss. They put in their reply. We get an opportunity to put in what's called a surreply. And so that's what we're putting in. And that should be filed within the next, I would say, hour to an hour and a half. But just to give you a quick idea, because it's obviously many, many pages, the preliminary statement gives you a great idea on just how qualified my lawyers are, Danya Perry, as well as Ben Brodsky. I mean, down in Florida. Danya, of course, here at both New York and Florida. But I got to be honest with you. I want you to hear the preliminary statement because you'll understand where the money is going and exactly what it's doing. And unlike Donald Trump, I don't have the ability to use 90% of the funds for my own purpose. It is all specifically for Danya Perry and for Ben. All right. So here it goes. Plaintiff Donald J. Trump's sprawling and frequently incoherent complaint appears to have two aims: retaliating against and intimidating Mr. Cohen and distracting from Mr. Trump's mounting and serious potential criminal exposure. Asserting cognizable legal claims was apparently not a goal. And indeed, Mr. Trump fails to plead essential elements of each of his purported claims. In addition, some of Mr. Trump's claims are clearly time-barred, as they are based on events that occurred well outside the limitations period. As Mr. Cohen showed in his motion, each one of Mr. Trump's claims should therefore be dismissed. Now it goes on, and it actually gets even worse. But I don't want to go into too much of the detail and so on. But it is basically a one-page preliminary. All right, here, I'll give you a little more.
Give us a little more.
Right?
Come on, you got the brigade here.
Mr. Trump's response fails to show otherwise. As for the statute of limitations, Mr. Trump's arguments for the application of a longer, more favorable statute of limitations are based on misconstructions of the relevant facts and law, dicta from inopposite cases, and mischaracterizations of his own allegations in the complaint. Moreover, Mr. Trump cannot identify any persuasive reason why Florida law should apply to his claims, given that the parties' relationship was centered in New York. And indeed, Mr. Trump's revelation in his opposition that the confidentiality agreement contains a New York choice of law clause provides yet more support for that conclusion. I mean, it is truly, as I said before, it's truly it's a masterwork. All right, I got to just give you a tiny bit more.
Give us a tiny bit.
Tiny bit more here. Mr. Trump's arguments on the merits fare no better. By and large, rather than identifying specific factual allegations in the complaint that would make his claims cognizable, he instead points to the very same conclusory allegations that only underscore the insufficiency of his pleading, the incoherence of his legal theories, and his entirely speculative damages claim. I mean, look, like I said, this case, lacks merit. It was retaliatory. The whole goal is to financially hurt me, as if that hasn't already happened enough. But we're not going to let that happen. And thanks to folks like yourself, and thanks to others who have found it on social media with the GoFundMe. If in fact you haven't, please, I ask you to, this is so important for holding Trump accountable for this malicious prosecution, this retaliatory action, simply to stop me from, being able to testify or to provide continued cooperation to the various investigations that are currently pending. I won't let it happen. I do need help. And short of that, I promise you that if you read Brito's documents and then compare them to Danya's and to Ben's, there is absolutely no correlation between the quality of legal, penmanship or scholarship here, then, it's just, there is no comparison between the two works.
If you look at Donald Trump's lawyers, whether it's Brito in your case, or he filed some other 800 billion trillion, Dr. Evil lawsuit against the Washington Post, just making up imaginary numbers. I think it was 3.2 billion. He brought the lawyer who filed that for Donald Trump was a solo practitioner who I don't think had ever filed the defamation case before. And so these are the people lining up to learn the lesson that MAGA stands for: make attorneys get attorneys, something that you've learned a long time ago and that you told everybody and warned everybody this is what was going to happen. Yet apparently they don't learn their lesson, or they want their 5 minutes.
It could also be, Ben, make accountability great again.
I like make accountability great again, but then I don't want MAGA to mean anything positive, because it is.
You're right. You are right.
Okay. One of the things you mentioned there as well, though, and I'll just point out to our viewers, it was interesting what your lawyers pointed out. So Donald Trump brought this case probably in a venue that it shouldn't have been brought in, but Donald Trump's lawyers don't even realize that just because the case may be pending in the Southern District of Florida in Miami Division, that doesn't mean Florida law applies. And the law that's applied has to have a nexus to the underlying conduct that is at issue. So Donald Trump apparently was citing all of this Florida law in his brief. And what your lawyers were pointing out to the judge is the lawyers at the most basic level are citing the wrong cases.
And do you know what the nexus that Donald's lawyers and are using in order to try to create the relationship to Florida? That we have podcast viewers who are in Florida. That's right. The political beatdown, mea culpa. My books, both Disloyal and Revenge, have been sold and purchased in the state of Florida. And therefore, that's the nexus. That is the most ridiculous argument that one can possibly make. And worse, in their own papers, in their opposition papers to our motion to dismiss, they turn around and they cite inaccurate case law in order to try to prove that their position, that their causes of action actually have merit. It's really a piece of writing, and I do expect us to be successful in this. I will also tell you and the brigaders that tomorrow is the day that Donald was noticed for the deposition. And the other day, and I mean it like yesterday, my counsel received notification from Brito that they were not going to go forward with it because either Donald is out of town or Brito is out of town, and of course provides no alternative date for the deposition, still of course remaining of the belief that they can ask for and that they should receive 90 days post the election in order to be deposed. I mean, this is legitimately how ridiculous that this case is becoming. The only problem, again, of course, is you got to finance these cases. And Donald knows that. And it's an old Donald Trump play from the playbook, which is, first of all, he doesn't pay the lawyers, so it's not as if he's worrying about the legal fees associated. But when you have a $500 million lawsuit brought against you personally, regardless of how stupid and ridiculous that the case is, you still have to defend it, and it's very expensive.
I really like the strategy here by you and your lawyers, which is a common sense strategy here, given the type of litigant you're dealing with. But not everyone would pursue this strategy, which is normally you may want to do discovery requests, like document requests and interrogatories and requests for admission, then do the deposition. But look, Donald Trump has made so many statements, incriminating statements publicly at his events, on his social media platform, that you pretty much have the body of information. And you know he's just going to play games during discovery anyway if you make those requests. So right out the outset of the case, ask for his deposition. Look, Donald Trump filed the case, so he should be ready to sit for a deposition in the case that he brought. And we all know that he's going to try to avoid that deposition like the plague. I also like that your lawyers have expeditiously pursued this case, because one of the tactics Donald Trump likes to do is file the case, get the headline, and then just hope the other side, because litigation fees are expensive and no one really wants to be involved in a lawsuit, that because Donald Trump is not going to aggressively prosecute these cases, or frankly prosecute them at all until he gets some order by a federal judge for failure to prosecute the case, he just thinks that he gets his headline and then it goes away. So I like that your lawyers have been very aggressive, set his deposition right away. And look, your lawyers probably knew that he was going to pull this stunt and a day before say, oh, he can't show up for the deposition. But now that's strike one. And then you go back and you say, okay, well then give us an alternative date. When they don't give you an alternative date, then you go to the court and you say, we've been trying to set his deposition. We've asked for alternative dates. We're not getting any. Judge, you need to compel.
Right, but Ben, I just got to interrupt you on this one, because the one thing that's not being mentioned here by you is the fact that Donald is the plaintiff. And when you are a plaintiff, it is incumbent on the plaintiff to move the case forward. It is not the responsibility of the defendant to push the plaintiff to be deposed. You nailed it when you said that you need to be ready. When you bring your lawsuit against someone, you as the plaintiff need to be ready to proceed forward, and almost immediately. Right? That's not what Donald's doing here. He's turning and saying he's so busy right now. And the funny thing is, you know what he's busy doing? My understanding, he's on the golf course, right? Or he's entertaining people at Mar-a-Lago.
There you have it, folks. Thank you so much for watching that. Again, it's such an honor to co-host the show with Michael Cohen, to get his perspective, to share his perspective with you, the Meidas Mighty and the Political Beatdown Brigaders. Make sure you all subscribe to the Political Beatdown podcast wherever podcasts are available. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We are on our way to 1.5 million subscribers here. Check us out at patreon.com/MeidasTouch, and see you next time.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.